Well, thank you very much, Mr. Chairman, and I especially want to thank all of our witnesses who are joining us today and taking time out of your lives. In Congress, we should really be working on ways to grow the economy from the middle out, not the top down. Over the last several decades, the middle class has gotten stuck with a shrinking share of America's prosperity, even as the biggest corporations have posted record profits and even as American productivity has increased. American workers' paychecks have stagnated, and many are struggling now to make ends meet on rock-bottom wages and poor conditions on the job. Unfortunately, once again, instead of sticking up for workers, some of our Republican colleagues are rushing to the defense of the biggest corporations that have an interest in keeping wages low and denying workers a voice to improve their workplace. When workers want to vote on whether to form a union, they aren't looking for special treatment. They are simply trying to exercise their basic rights. But too often, big corporations use loopholes in the current election process to delay a straight up or down vote. Workers have the right to vote on union representation in elections that are free from unnecessary delays and wasteful stall tactics. And our country should not turn our backs on empowering workers through collective bargaining, especially because that is the very thing that helps so many workers climb into the middle class. As a reminder, by law, workers have the right to join a union so they can have a voice in the workplace. But right now, the NLRB's election rule is outdated. The NLRB's new representation rule makes important but very modest amendments to guarantee a free and fair election process in today's modern workplace. For example, the old election rules are vulnerable to frivolous litigation, which could drag out elections and put workers' rights on hold. The new rule will reduce unnecessary litigation on issues that aren't relevant to the outcome of the election. In the past, employers had to send out mail through the post office, which cost time and it costs money. This new rule brings the rules into the 21st century by letting employers and unions file forms electronically. And it will allow the use of more modern forms of communication to employees through cell phones and email. These changes aren't just good for workers, they're also good for employers by streamlining the election process. Some of my colleagues on the other side of the aisle take great offense to these modest changes. Instead of standing up for workers across the country who are struggling with stagnant wages, Republicans have chosen to challenge these common sense reforms. Let's be clear, this rule is about reducing unnecessary litigation. And using cell phones and email to transmit information in 2015 is just common sense. A worker wanting to have a voice in the workplace is not an ambush. It is their right as guaranteed by the National Labor Relations Act and by the First Amendment of our Constitution. Workers having a seat at the bargaining table is critical to America's middle class. It's not a coincidence that when more workers can stand up for their rights, wages increase, workplaces are safer, and access to health care goes up. In short, middle-class Americans are better able to share in the economic prosperity that they have earned through their hard work. So instead of attacking workers who want to collectively bargain, I hope that our colleagues on the other side of the aisle reconsider this approach and work with us to protect workers' rights and increase wages and grow our nation's middle class. And I do truly hope that Republicans and Democrats can break through the gridlock and work together on policies that help to create jobs and expand economic security and generate broad-based economic growth for our workers and families, not just the wealthiest few. Thank you, Mr. Chairman. Ms. Spencer, can you respond? I'm confused by the fax machine on Friday discussion. Can you clarify that?
Sure. First of all, if a petition is filed on a Friday and the union gives notice to the employer on Friday, as would be required under the rules now, where only the region gives notice currently, the hearing isn't scheduled for 8 days because you wind up in the notice. It's 8 days from the time that the notice is effectively given, and you don't count that day, so you move over on the weekend. But you also aren't doing it necessarily by fax anymore. Prior to filing the petition, there's a box that the union has to answer, which says whether or not notice has been given to the employer. In almost virtually every case, notice is given to the employer before the petition is filed with the board, because the employees, as an act of solidarity together, give their request for organization to the employer, who then ignores it. Then, under the new rules, in addition to fax service, email becomes an acceptable way to serve, which is something that employees use and employers use on a regular basis. It is served with a notice of procedure, which explains how to post the notice that the federal government is going to require posting with it, so that you're not walking into a trap of posting it incorrectly. Those things are taken care of by the new documents that will explain the process to the employer, a benefit that they do not currently have, and it makes it easier for an employer who does not have counsel right away to be able to respond in an appropriate manner.
So we've heard a lot about this is permitting a quicker process for elections. In fact, that's what the title of the hearing sort of implies. Can you tell me, in your view, is the point of this rule speed?
No, it's to take out the parts that aren't necessary. Right now, there's a lot of gamesmanship in how this process works. There's a lot of wrangling for position. The employers ask for an extension for a hearing date, even in a unit of 10 people. In a unit of 10 people, the employer pretty much knows who their supervisor is. If the union is requesting all 10 people in a unit of 10 people, there are not many legal issues or any legal issues that should have to be worked out, such that it takes over a week to prepare for a hearing, or in fact that it even necessarily requires an attorney. There are many corporations that do these hearings without attorneys on a regular basis. The week delay before the hearing is set, or even having consistency in when the hearing is set, would reduce unnecessary delay that is currently built into the system. A closing brief issue that has to be filed a week after the hearing is held is not necessary in a unit of 10 people. The only issue that's going to come up there, of all of your employees are part of it, is one of them a supervisor. There is long-standing board rules and board regulation as to what defines a supervisor. A closing brief is not necessary. We get rid of that week. It also gets rid of the 25 days of review in between the time a decision of direction of election issues and the time that the election can be held, but allows the employer, if there is a problem or a concern regarding the decision and direction of election, to seek review of that if it's still necessary after the election is held.
Well, I heard Mr. Carter say that elections could take place in as little as 10 days. Ms. Melito said it's in as little as 14. Does the rule set a specific time frame for when that election should occur?
No, there are only a couple of points that actually have time frames. The first is the setting of the hearing, which is for the 8th day, unless there's extraordinary circumstances, and then there's extensions and discretion for those extensions. The other portion that has a definite time period is if there are objections to an election, they'll be heard 21 days after the election is held. Other than that, the time periods are all flexible under this rule.
Okay, and it's my understanding that the final rule set an election hearing to begin 8 days after the hearing notice is served. And isn't it true that a number of the board's regions, maybe even a majority of them, regularly schedule hearings 7 days after the election petition is filed, and therefore the rule just actually standardizes that existing practice?
I deal mainly in 4 regions in California. California has 4 regions that cover it. In 3 of them, the standard is already 7 days. In the other one, it is 10 days. So this really is just conforming to the best practice that's already out there.
Okay, and I want to ask you one more question. We've heard claims that providing employees' email and phone numbers will intrude on workers' privacy. The board accepted tens of thousands of written comments over the course of 141 days and heard over 1,000 transcript pages of oral commentary over 4 days of hearing. As far as you know, did any of that voluminous commentary reveal even a single instance of misuse of contact information contained in voter lists in the past 50 years the board has required that such lists be provided to unions?
I haven't seen any commentary to show it, and at the public hearings where I was on the panel about the new information, there was not a single concrete example provided of that. Currently, home addresses are provided, and unions have every reason to keep that information confidential to protect the workers that they're seeking to organize.
And does the rule contain protections for workers' privacy?
Yes, because the list is limited in what it can be used for, which it currently is not under the Excelsior Underwear rule.
Okay, thank you very much. I just want to thank all of our senators who participated and our panelists, too, for your insight into this. I hope at the end of the day that we all agree that when workers want to vote to join a union, that the election process should be fair and transparent. And I know we have a disagreement on this issue. I'm sure we'll hear more about it. But I hope at the end of the day that we remember our role is to make sure that workers have a voice in that process. Thank you, Mr.
Thank you.